Court is calling 2023 CR 9788 and 2026 CR 001199 State versus Elora. Posada, can I have parties announced?
Renee Munoz for Ms. Posada.
And are you Ms. Posada?
Yes.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number, Ms. Posada, did you review, just 1 second. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes.
And the cause number ending in 99, did you review the waiver of indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it? You have a right to have a grand jury hear the evidence in this case and decide on whether or not it's sufficient to render an indictment. Your attorney has a right to the passage of 2 days upon presentation of the information, and also 10 days to prepare for trial. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea today?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information, and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In that cause number, did you review the information with your attorney? Did you understand it? And in the other cause number, did you review the true bill of indictment with your attorney and did you understand it?
Yes.
Counsel, in each cause number, do you waive the readings?
Yes, Your Honor.
And state in each cause number, are you proceeding on the information in the indictment as presented?
Yes.
And the cause number ending in 9, you're charged with an injury to an elderly or disabled person. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If I grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court will find you guilty and sentence you, could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine. And the cause number ending in 88, you're charged with the offense of credit card or debit card abuse. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. In that cause number, if I grant your application for deferred adjudication, if for any reason your deferred adjudication is revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand? And each cause number, if you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will withdraw your plea. Did you understand?
Yes.
In each cause number, you have a right to jury, a right for you or your attorney to cross-examine and confront any witnesses, the right to remain silent. By entering into these pleas, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers? I'm going to need you to speak up so the court. Counsel, in each cause number, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does.
Do you believe she's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
And each cause number, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes.
In each cause number, if you're not a U.S. citizen, by entering into these pleas, you will be deported and denied naturalization. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it? In each cause number, the cases are to run concurrently. The state is taking in consideration 2026 PF 02856. This is run concurrent with DC 2023 CR 9788. And the cause number ending in 9, there's a $1,500 fine. In the cause number ending in 8, there's a $1,000 fine. There's to be restitution in cause number 8 of $131.75. Family violence, you're not allowed to own or possess any weapons or ammunition, and you're also not allowed to be designated as primary custodial parent. Did you understand? Did you understand that to be your plea in each of the cause numbers? Defense, is that the plea?
Yes, Your Honor.
State?
Yes, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, any such motions?
No, Judge.
Outside the agreement, in each cause number, the state is requesting that your community supervision be for a term of 5 years. 120 hours of community service, no contact with the complainant, and cause number ending in 8, anger management, MRT, TAP evaluation and parenting classes. Did you understand those from the state, and the court does not have to follow those recommendations? And cause number 2026 CR 001199, how do you plead? Guilty, not guilty, or no contest?
No contest.
And cause number 2023 CR 9788, how do you plead? Guilty, not guilty, or no contest?
No contest.
State in each of those cause number any evidence to support the defendant's plea?
$1 causes.
No objection.
Thank you. And state, have you had a chance to speak with the complainants in each of those causes?
And yes, okay.
All right, you may be excused. In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
In each cause number, the court will find that in each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments in each cause number, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
All right. So what is your relationship in cause number 9, the injury? What is your relationship to the person in that cause number?
I'm her mother.
And how old is she?
11 years old.
Okay. All right. So it appears that your client has some substance issues.
In speaking with her, Your Honor, she didn't notify me about any drug issues particularly. Ms. Posada, do you have any issues with substance?
No.
All right. So I'm basing that upon the police report. The police are stating that when they came out, you were intoxicated. Well, let me change that. They said that you were slurring your words.
Okay, she had been drinking that evening, and it appears, Your Honor, and that appears to be the basis of those observations. And in our estimation, there was a verbal altercation with her and Christian Pedrosa, her husband, and some alcohol may have been involved at that evening, but we don't believe it's a continuous thing, or she has any significant issues with that, with that alcohol issue. Judge.
All right. And has Child Protective Services been involved with her?
Yes, Your Honor.
And what is the results of that?
They are recommending upon her release to put her on a safety plan, so she can work into getting a better relationship situation with the child. I asked my client about arrangements for the child. Angel's not going to be living at the household home that she's going to be going back to her husband Christian until the CPS plan is followed, and she can safely meet and visit with her and just reestablish that relationship.
So there is not any minors that are being allowed in the home at this time?
She has other children that she has with Christian Pedrosa.
But are they in the
Yeah,
home,
they do.
minors?
They do reside at the home, Judge.
And Child Protective Services has nothing to say about that?
I haven't had any dealings with them. Did they tell you anything about that?
They just said I was going to be placed in the safety plan with someone to be in the house with us at all times with the kids.
All right. And cause number 2023 CR 9788, court is going to sentence you to $1,000 fine. That will be probated 5 years deferred adjudication. This is to run concurrent with 2026 CR 0119. There's to be regular reporting by Zoom or in person, regular random UAs. There's going to be a TAP evaluation. Out of custody, follow recommendations for TAP. There's going to be 120 hours community service restitution. There's to be 1 hour deducted for every completion of sober support meetings. There's going to be restitution to the complainant and no contact with the complainant. And that restitution is in the amount of $131.75. There's going to be field visits one time per month until further notice. And there's to be no residing in households with minors. Counsel, that's until the safety plan is provided to probation.
Yes, Your Honor.
And probation, that's the safety plan from CPS. Probation, is there anything else in regards to that case? Proof of employment within 45 days, no employment as a home health care provider or with minors. All right, next we're proceeding in 2026 CR 001199. And that cause number, there's an affirmative finding of family violence. There's with the complainant, no harmful or injurious contact with regular reporting by Zoom or in person, regular random UAs, concurrent with 2023 CR 9788, taking consideration 2026 PF 02856, $1,500 fine that will be probated. No residing in households with minors, 200 hours of community service restitution, 1 hour deduction for every sober support meeting completed. There's going to be 20 hours deducted, and I'm ordering anger management, and there's going to be 100 hours deducted, and I'm ordering parenting classes, and there's to be field visits one time per month until further notice, and no residing in households with minors until the safety plan is presented. Probation, and proof of employment within 45 days, no employment as a home health care provider or with minors. Probation, is there anything else?
The term, Judge, for that one? The term for that one?
Oh, thank you.
That one does.
Yes, 5 years deferred adjudication. All right. Anything else you need from the court to be successful? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Thank you, Your Honor. I appreciate it.
Sorry.
Okay, I got it. You ready?
Yes. Hello.
Hello.
So why are you before me today?
I violated my no contact order.
And why would you do that?
My concerns are my daughter's mental health.
Well, no, but there's a no contact order in place. And there's a reason there's a no contact order in place. There's a no contact order in place with this court. And on the civil side, there's also a no contact order. And then my other issue is then the grandmother starts blaming the party you were not to have contact with, telling them it's their fault that if you go to prison, and it's not, it's your consequences. So I don't know why you're violating my conditions that I have set for you. And there's a reason why I put those conditions in place. And your attorney knows there's a reason why I put those conditions in place. And you just want to violate it and pretend like you're violating it for some benevolent reason. And you're violating it because you want to, because if you cared about these people, you wouldn't be in this position anyway. And the fact that there's another case on the civil side that has absolutely nothing to do with this, that's all you. And so did you get a chance to read what your mom is telling this other person?
Judge, I gotta ask, why is my client being held responsible for something her mother says?
No, because the reason why I'm telling her that, she claims that she's concerned about the mental health. And that's an issue, because that person who said that about her, the only way she knew about this is because you told them. And this is all a family situation. And you're violating my rules, and you're violating the rules on the civil side. And I'm telling you right now, this is the only conversation we're going to have with your violation of these court's rules. Do you understand?
Yes, ma'am.
Next time, I'm not doing a client compliance hearing. If everything is in order, they're going to present me with a motion to revoke. I'm going to sign it. Then we'll have a hearing, and I'll see it by a preponderance of the evidence. Your attorney will tell you that's the burden on motions to revoke. It's not beyond a reasonable doubt. Do you understand?
Yes, ma'am.
Judge, I have spoken to my client. I spoke with her before the hearing was had. When this incident initially occurred, she knew that this was a possibility. So she hired me. I went into full detail explaining to her, especially in your court, how this works. So she is terrified, and she'll never be back here again.
The range of punishment for what your charges with is up to 10 years in prison for this case. And what gets me is you're an adult, you know the rules, and you're still violating them. That's a problem. Probation, Add MRT to her conditions. Is there anything else?
Okay.
Do you understand the court's orders? Do you understand that there's to be no contact?
Yes, ma'am.
Do you understand that on the civil side, they're saying no contact as well?
Yes, ma'am.
From here on out, everything that you do, you need to ask yourself, is this something that could potentially result in me going to prison? If the answer is yes, don't do it. If the answer is maybe, don't do it. Now, the MRT is going to help you with your decision making. And what you should have done with this, and your attorney will tell you, is you should have contacted the people on the civil side and say, hey, these are my concerns. And you should have sent them a letter. These are my concerns. And they would have addressed that. You should have came back to court and say, hey, I have these concerns. And it would have been addressed. Do you understand?
Yes.
And you need to speak to your mother and tell her to stop blaming the party that you had contact with. Do you understand?
Yes,
Well, I'm
ma'am.
gonna have that conversation with mom.
Oh, yeah, because that does no good for that person and their mental health. So,
Of course, Judge.
anything else?
Judge, in addition to the MRT, the CSO is requesting field visits be done twice a month instead of once a month, as well as another compliance hearing in 90 days.
All right, we'll have another compliance hearing in 90 days. And the field visits will be twice a month.
Sounds good, Judge.
All right, thank you.
Should I get that date from Norma?
Yes. Norma, 90-day reset for compliance.
This case starts with the defendant facing 2 serious charges, including injury to a child and credit card abuse, both carrying heavy prison time instead of sending her away immediately. The judge gives her a chance. Deferred adjudication, that means no prison. If she follows every single rule, we're talking strict conditions: no contact with certain people, no living with minors, mandatory classes, community service, and constant supervision. One mistake, and everything changes. At first, she agrees. To everything, says she understands. Says she comply. But then, things take a turn. She ends up back in court for violating a no-contact order, one of the most important rules in her case. Her excuse: she claims she was worried about her daughter's mental health, but the judge immediately shuts that down because there were legal ways to handle that situation, and she chose to ignore them. Even worse, she tried to shift blame onto others. Instead of taking responsibility, that's when the judge gets serious. She makes it crystal clear. This isn't a misunderstanding. It's a choice, and choices like this lead to one place: prison. Now the stakes are even higher. More restrictions, more supervision, another chance, but barely. And the judge leaves her with one final warning. If there's even a chance, your actions could send you to prison. Don't do it, because next time there won't be another opportunity.